We'll hear from the appellant.
Good morning, Your Honor. Brian Smith from the Memphis Bar. I am here on behalf of Eugene Moxley, the appellant, and I will reserve 5 minutes for rebuttal.
How much, I'm sorry?
Five
Five?
minutes.
All right.
This is a unique case. I know that these cases come up quite often with the notice letters, but this is a unique case in the sense that the HIP authorization was facially valid. There are no substantive issues with the HIP authorization, and unlike other cases, we took the Supreme Court's advice in Martin and submitted evidence. And the undisputed evidence in this case, is that there was compliance with HIPAA and that each of the defendants had access to Mr. Moxley's medical records. So I want to start out with because I know that in the Martin dissent, Justice Kirby talks about the virtual reality of the courtroom that we've created around these HIP authorizations, and I want to talk about what happens in the real world. And this is based on the affidavit of Pamela Hernandez, which is in the record and was considered by the trial court when this issue came before him. In the real world, when doctors need medical records, there's not one particular way that they have to go about doing it. There's multiple ways that they can go about doing it. So, for example, if you were going to a cardiologist and the cardiologist needed the records from your family doctor, there's two or more ways that they could happen. The patient could give the cardiologist a HIP authorization, allowing them to request the records from the family doctor, or the patient could go to the family doctor and give the family doctor a release allowing him to send the records to the cardiologist. Ms. Hernandez, in her affidavit, says both of those are perfectly acceptable under HIPAA, under industry standards. And both of them would allow the cardiologist access to the patient's records. And that's what's at issue in this case. Ultimately, this issue turns on whether or not the defendants had access to Mr. Moxley's records. This case, as you know, has been up. This is the third time that it's been up. We kind of picking up where we left on Moxley 2, where Judge Armstrong noted that the issue of whether or not there has been substantial compliance is much more complex than determining whether or not there has been strict compliance, and that ultimately the decision turns on whether or not each of the defendants had access to the patient's medical records. Ms. Hernandez, who has over 35 years in the healthcare industry, who is a HIPAA compliance officer, who had managed HIM departments, health and information management departments, has testified by affidavit that the HIPAA authorizations that were sent to each of the defendants were fully compliant. They contained all 6 core elements required in Stevens. They required the additional statements required by HIPAA, and they authorized the release of medical records to each of the other defendants. That's all that's required. And she says that had these authorizations been processed as they should have been, that what would have happened is when the authorization came in, they would have handed it to the HIM department. The HIM department would have seen that St. Francis was authorized to release records to Dr. Kaur. They would have processed the records, sent records to Dr. Kaur with a bill, and he would have had those records. He would have had access to those records. One of the things that Ms. Hernandez discusses is that HIPAA, and I think this is important to keep in mind, HIPAA is a privacy issue. What it does is it maintains the privacy of the patient's records. And it is directed to the healthcare provider who has those records. Nobody else. It's directed to the healthcare provider who has those records. And what it says is that in order for a provider to release records, they have to have a written authorization from the patient. That's all it really says when you boil it down, which they had in this case. HIPAA does not limit who can ask for the records. It does not limit how those records can be released. It doesn't matter. It doesn't limit how those records can be released. All it says is that if a provider is going to release access or we're going to release records, they have to have a written authorization from the patient, which they did in this particular case.
Mr. Smith, let me ask you a question. Do we have any dispute in this case that the release itself was a HIPAA-compliant release?
There has been none, to my knowledge, no, and they have not raised any. And I think in their brief they acknowledged that it did contain all 6 core elements and it was fully HIPAA compliant.
My understanding from reading the briefs in this case is that this release allowed, this HIPAA release essentially allowed the release of records.
Correct.
Do you have any case law that you can point to that says that a release crafted such as this one was has been deemed to be substantially compliant under the statute?
No, and in fairness, the only case I think that's out there is the Parks case, which has been cited by the defendants, which I do think is distinguishable from this case in 2 significant ways. One is the release in Parks was not complete. They left out the reason or the purpose for the authorization, and that is one of the 6 core elements. And so the court said that in connection with this made it non-compliant. But also in Parks there was no evidence like we have in this particular case. We have evidence from a HIPAA compliance officer who says that this was fully compliant, and when the defendants received these releases, they should have released the records to all the other defendants. But that's the only, there's another case that I can't talk about that is not for citation. We included that in the brief simply in case this case goes further. We didn't want to raise the issue of there being a split in authority for the Supreme Court. But so there's another case, but I can't talk about it. The only case I think that is on record is the Parks case that sort of deals with this issue, but I do think that the facts in that case are significantly different than this case because it was a non-compliant HIPAA authorization and there was no evidence of compliance. And if we go back to the framework that the Supreme Court set up in Martin said that once the defendants come forward and they raise some issue with the compliance, that the burden then shifts to the plaintiff, and they specifically say that the plaintiff can come forward with proof, which we did. We came forward with the affidavit of Ms. Hernandez, which, by the way, is undisputed. The defendants could have at any point in time, St. Francis is a big corporation with a HIM department. They could have gotten affidavits from people in the department to say that it was not compliant or that they did not have access to the records. There's no evidence in the record that the defendants did not have access to the records. The only evidence in this record is that that this was a fully compliant authorization and that they had access to the records.
Question, I get confused as I think about this in this case, but one defendant gets the HIPAA authorization that they are authorized as defendants to release the records
Correct.
of Mr. Moxley. But there's no indication that this one defendant, for example, knew that they could go to the other defendants because they had the same type of release as you would normally get. To obtain the records, you would get one from all potential other defendants.
Sure, but I disagree with that. The record is clear that they all got a letter. All the defendants got a letter that said everybody else receiving, and they had a list of everybody who received the notice. And they had a list of everybody receiving notice, and at the end of it, it said, everybody on this list is getting releases allowing them to disclose the records to everybody else. So it was known. And I would say, too, like Justice Kirby talked about the virtual reality, I don't think we can ignore what happens in practice. I mean, what happens in practice is St. Francis gets a notice letter. Ms. Copeland's their lawyer. They give it to their lawyer. They look, and if they know who Dr. Kaur's lawyer is, they call him. If not, they call Dr. Kaur's office, and they say, who's your lawyer? And then the lawyers get together. I mean, it's not like when they get these letters, they go, I don't know what this is. This is the first time I've ever seen this. I mean, they know exactly what they're getting and how this works, and they talk to each other. That's part of the investigation. They talk to each other to figure out what's going to happen. And so to say that they didn't know what was going on or they didn't know how to get in touch with the other defendants to figure out what was going on is, I think, sort of flies in the face of reality. I mean, it's just not what happens in these cases in reality.
Mr. Smith, don't we have case law that addresses exactly what you're talking about, though?
Yeah, the Parks case is, I think, the only case.
I'm sorry, that was a very poor question. What you're talking about when you answered Judge Morgan's question, that the defendants essentially could have done something, could have acted, could have accomplished the desired result. And don't we have case law on what obligations that those defendants have under this release, as far as whether they have an affirmative obligation to take an affirmative step to attempt to get records?
So I would answer that by saying the cases I think you're talking about are the cases that say the defendants don't have to test the authorization.
Correct.
Those cases specifically say the defendants don't have to test a facially invalid or facially deficient or incomplete HIPAA authorization, which you don't have in this case. And it's true, and I'm out of time, but if I could finish.
You can answer the question, yes.
One, like I said, those cases are a little bit different than this case because we have a facially valid release, that it was complete. It's not a facially invalid. They don't have to test those. And two, I guess technically they don't have to do anything, but if they choose not to follow up and try to get access to the records, and they're wrong ultimately about the state of the affairs, then they've just given up their opportunity to investigate the case. They don't have to do it, but they do it at their own peril, I guess is the way I would say that.
Question I may, and I apologize holding you over, but we know it doesn't technically comply. Now, whether it's substantial or not is an issue we have to address. But then you get to the issue, and I was looking at what I'd read, does it frustrate or interfere in some way with that section?
And that's why I said that this case ultimately boils down to whether or not the defendants had access to the medical records, because that's the test of prejudice in these cases. Do they have access to the medical records so that they can investigate these cases? And I go back to the only evidence in this case is that they did have access to the medical records. That's the evidence in the record, is that from this, and like I said, the defendants could have come forward with that proof of their own. They could have deposed Ms. Hernandez. They could have gotten affidavits from people in their health information management departments. There was a whole lot of things they couldn't do. They didn't come forward, I believe, because they know we're right, which is they had access to the medical records, that this is, but just as Kirby was talking about, the virtual reality that we've created in these courtrooms, it doesn't really match reality in the real world.
That's the Martin case in the dissent.
Correct, Your Honor.
Thank you. We'll hear from the appellee.
Good morning, Your Honors. My name is Megan Lane. I represent St. Francis Hospital and Nurse Kirstna Norris Chapman in this case. My colleague, Kim Francis, represents Dr. Kaur in the urology group. We have decided that I will take about 12 minutes of time, and Mr. Francis will follow up the last 3.
All right.
We agree with a lot of the things that Mr. Smith has suggested to the court today. We agree that this is a unique case because the authorizations that the providers received were the wrong authorizations. We've got to come back to the simple fact of this case that continues to get muddied time and time again, that this was a mistake. The plaintiff acknowledges and calls it an envelope stuffing mistake. He did not intend for the providers receiving the notice to get what they got. Nurse Chapman received authorization she wasn't supposed to receive. As you said, Judge Morgan, the typical way these work is the providers receive releases that allow them to send out to the other providers the records request. And so they would have a release in hand that allowed them to obtain. So all they have to do is stick it in the mail and get the records that they need. First, plaintiff tried to cure the mistake in the trial court by arguing that it was not substantial compliance, but there was extraordinary cause that excused that non-compliance with the statute. The trial court disagreed, this court disagreed, and so we're back again to test whether or not the wrong HIPAA authorizations that were received were still, in fact, somehow substantial compliant with the statute. I want to address briefly, very briefly, the expert affidavit that Mr. Smith relies on heavily for his argument. And to make clear, we're not addressing whether or not the authorizations were compliant with HIPAA in this case. The issue is, did the authorizations substantially comply with 121A2E? Did they allow the providers receiving notice to obtain the medical records? That's the test here. That's the issue here. Mr. Smith did submit an affidavit of a purported expert 3 days prior to our hearing. We did not have the opportunity to test this purported expert's qualifications, nor did we have any time to depose this purported expert. The expert affidavit states that the authorizations were substantially or facially compliant with HIPAA because they contained all the 6 core elements. Again, we're not disputing that fact. What we're disputing is the records that the providers received allowed them to do nothing. Had another provider sent a letter because they perhaps got the correct authorizations, say Dr. Kaur had not received an improperly stuffed envelope and he got the authorizations he was supposed to get, if he had sent those to Nurse Chapman, then she would have been allowed to release the records. The authorizations they received did not allow them to contact the other providers, did not allow them to do anything other than release their records, and that is not substantial compliance with the statute. And so to rely on this expert affidavit, we submit that it wasn't considered by the trial court. If you read the transcript of the argument from the remand proceeding, if you read the trial court's order, there is nowhere in which the trial court considered this affidavit, most likely because of its late file in the record. Again, this court has appellate jurisdiction only. We submit it was not considered by the trial court and therefore is not properly before this court to consider as evidence either. Now again, going back, there is a big difference between substantial compliance with HIPAA and substantial compliance with Section 121A2E, which is the issue here. We agree with Mr. Smith that the stated purpose and benefit of the statute 121A2E, is to enable the defendants or the providers who receive notice the opportunity to access the plaintiff's records so that they are able to evaluate the substantive merits of the plaintiff's claim. Now, in order to do that, they have to be able to access the records. What the providers received in their hand did not allow them to access anything. No records, they weren't allowed to contact the other providers. Mr. Smith indicated to one of Justice McGee's questions that the only case he was aware of was the Parks opinion, which we do submit controls in this case, but there was a recent opinion that was actually authored by Justice McGee in May of 2025 that is perhaps more on point to this specific issue, and that is Crenshaw versus Methodist Healthcare. In that case, the plaintiff's authorization that was sent out to the providers was in fact substantially compliant with HIPAA, contained all 6 core elements, and arguably was more compliant in that case than in this case because every single provider was listed on the authorization. And so in the you're allowed to release section, all the providers. It was almost like a checklist. In the allowed to disclose or obtain, all the providers. However, there was a little line next to every single provider's name that wasn't checked, but it had all the information anybody needed on the record, or on the authorization itself. The Crenshaw defendants moved to dismiss, saying that it was not substantially compliant with the statute because there was a blank and they didn't know who was allowed to obtain or disclose records in that case. The plaintiff's argument is actually very similar to Mr. Moxley's argument here. He argued the authorization was fully compliant with HIPAA, it was missing 0 out of the 6 core elements, and that all the defendants had to do was mail out the authorizations, and in the real world, they would have received the records, just like Moxley's argument here. The plaintiff actually argued in Crenshaw that it was absurd to suggest that the defendants did not have a duty to attempt to mail out the releases. The trial court disagreed and found that the defendants did not have a burden to correct, complete, or even test the authorizations. This court agreed again in spring of 2025 that the burden is on the plaintiff sending the pre-suit notice to comply with the statute, and that the providers are not required to take any action to bring the authorizations into compliance. That is exactly what the plaintiff is asking here. Moxley is suggesting that due to his envelope stuffing mistake, the providers needed to take action to correct that mistake. They should have just picked up the phone, called their lawyers. The lawyers should have called other people, coupling with the notice letter, and sorted it all out for the plaintiff. It is not the defendant's burden to comply with the statute. It is the plaintiff's. And again, the provider receiving notice did not have the authority, per what they received in their hand, to do anything. They didn't have the authority to call the other providers and say, what did you get? I've got this release. It seems as if you may have gotten one as well. They didn't have the authority to do that. All they had the authority to do was release their own records. We submit there's no competing authority on this case. The controlling authority for this court is Crenshaw and Parks. We're not going to spend a lot of time talking about the case nobody can talk about, but we simply aren't waiving any arguments that our position is there's no split of authority on this issue. Both the short opinion, which is the case we cannot discuss, was denied appeal from the Tennessee Supreme Court. Likewise, the Crenshaw opinion, they requested permission to appeal. The Tennessee Supreme Court denied that. So it's our position that the Tennessee Supreme Court has spoken on the issue. The cases that are published and allowed to be cited are the cases that control in this specific issue.
What's the site on Crenshaw?
Can give that
It's the
to
western
you.
section?
It is. So it is a 2025 Tennessee app, Lexus 162. The actual Court of Appeals record site is W2024-00682 COA R3CB. And that was heard in the January session, filed May 7th, 2025. Your Honors, the plaintiff also suggested that the defendants had the ability to know what all the other providers received. So they had to assume that the other providers also received an envelope stuffed incorrectly, but they could have used the letter, which is actually a compound authorization that has been rejected by this court and by the Tennessee Supreme Court. Compound authorizations are not permitted. That's JAC versus Methodist Healthcare Memphis Hospitals. The law is clear. The plaintiff cannot rely upon the notice letter in conjunction with the HIPAA authorizations to obtain substantial compliance with the statute. The providers must be able to access or obtain the records with the authorization alone. The form must allow that on its face. The Parks opinion is controlling, and the issue addressed is, it was one, was it compliant with HIPAA because there was a missing core element, but two, was it compliant with 121A2E because the release was similar to this one where it did not allow the providers to obtain but only to disclose. As we're all aware, because this case has been cited on, again, now the third appeal, the Parks Court addressed, just like this one, that the plain language of the HIPAA form itself did not allow the provider who received that authorization to obtain the records, and therefore it was not substantially compliant, because that is the test for substantial compliance with the statute. It's not about the number of missing elements on the HIPAA authorization form. The question is, does the HIPAA authorization allow the provider who received the authorization to get the records from the other providers? Just like in Parks here, the authorization that, for example, Nurse Chapman received did not allow her to obtain the records from any other provider. Therefore, the authorization was not substantially compliant with the statute. We're not, again, addressing substantial compliance with HIPAA. It's substantial compliance with 121A2E. Briefly touching on prejudice, because the plaintiff suggests there was no prejudice because we could have tested the authorizations. Again, that position has been rejected. The court in JAC says that a defendant's claim of prejudice is not waived by failing to attempt to use or otherwise test an allegedly defective authorization if the defendant believes it to be defective. So it's not the plaintiff's duty to comply with the statute. It's the plaintiff's burden. Your Honors, this case, the plaintiff's position is pretty simple. It's that he can substantially comply with the statute by stuffing 11 envelopes wrong, not once, not twice, not 3 times. He made the same mistake 4 separate times with 4 separate mailings. And then he can sit back and do nothing else, make the providers who receive the notice sort it all out, figure it out how to get the records with authorizations that only allow them to release their own records. The law is clear. It's a plaintiff's burden to comply, not the defendant's. Thank you.
Good morning.
Good morning.
Kent Francis with the Shelby County Bar. Pleasure to be here. I represent Dr. Kaur and the urology group in this matter. I wanted to address very quickly a minor issue that showed up in the briefs. In the ruling at issue, Judge Wooten dismissed this case without prejudice, so whether he dismissed it, whether he erred in dismissing it with prejudice is not before the court, because that's not what happened. We're certainly not waiving any statute of limitations arguments or defenses we might have in the event the case is refiled. I wanted to address that. I think on the substantial compliance issue, Ms. Lane did an excellent job. We join in all of her remarks, but I think it's helpful when we look at substantial compliance, what does it look like when a plaintiff does not strictly comply but substantially complies? So what is substantial compliance? And there are examples. We have law on this. In Clary versus Miller, the plaintiff gave the providers everything that the plaintiff was supposed to give the providers. The providers received everything that they were supposed to get, but the plaintiff didn't attach copies of the authorizations to the complaint. That was deemed to be not strict compliance, but substantial compliance. In the Thurman case, the plaintiff timely sent pre-suit notice, sent all the authorizations, but didn't file the required affidavit for the person who mailed the notice. And then in the Arden case, the plaintiff substantially complied. The plaintiff sent the notice letters by FedEx rather than U.S. Postal Service certified mail return receipt requested. So you see the pattern. In those cases, there is substantial compliance because the providers were equipped with the actual means to evaluate the substantive merits of the claim by enabling early access to the records. They had everything they were supposed to get. They had everything they needed to evaluate the claim. This case is different because the providers did not get authorizations allowing them to obtain records from the other providers. So it's clear when you look at the examples and you look at this case and you look at the standard, the equipped with the actual means to evaluate the merits, it's clear that there was no substantial compliance here. Dr. Kaur, the urology group, and the other defendants had no duty to try to work this out, to try to call each other, figure out who got what. I find it interesting that the appellant acknowledges that a defendant who gets a deficient authorization has no duty to do anything with it, but he's saying a defendant who gets no authorization allowing him to obtain records or her to obtain records has a heightened duty, and that doesn't make any sense to me. I'm out of time. If I can answer any questions the court has.
I see none. Thank you.
They brought up the issue that there's a mistake. I mean, the whole idea of substantial compliance is that there can be some level of mistakes, but still compliance. The issue is whether or not, and I think we all agree on this, the issue is whether or not the defendants, the plaintiff, or in this case, Mr. Moxley, gave the defendants access to his medical records. That's the standard of prejudice, and that's how you measure these cases. So that's the issue in this case, and the evidence in this case is that we did give them everything that they needed to access the records. Remember, all HIPAA is directed at is the person with the medical information. They have to have permission before they can release it. In other words, the patient stand is the gatekeeper. They're the ones that can decide, does somebody else get the medical records or not? In this particular case, Mr. Moxley clearly gave everybody permission to release his medical records to everybody else. Therefore, they had access to the medical records. I think the defendants have acknowledged that. The defendants have acknowledged that there was nothing wrong with this HIPAA authorization, that it fully complied, and that they had access to the records. Their complaint, this is their complaint as I understand it. This is the release that allows St. Francis to release records to Dr. Kaur. All right. Instead of sending this to Dr. Kaur so that he could hand it to St. Francis and ask for his records, Mr. Moxley sent this straight to St. Francis so they could release the records. The net result is the same. Dr. Kaur gets the medical records. Their complaint is strictly procedural. It's not substantive, it's procedural. Their complaint is they didn't have a piece of paper that they could hand to the other defendants and ask for the records, even though they could get the records. There's really no dispute of that. They had access to the records, which is the measure of prejudice in these cases. They had access to all the records. Their complaint is that they couldn't hand a piece of paper to the other defendants and ask for them. And if that is what is required, I would submit that is a strict compliance standard. It's not substantial compliance. You're saying you have to strictly comply with the statute, which is not the standard in this case. Everybody acknowledges that. The point is, could they get the medical records, and could they investigate the case? And the answer to that is yes, based on Ms. Hernandez's affidavit. I apologize, I missed Crenshaw. I'll be happy to file a supplemental brief if you want me to address that issue. From listening to the arguments, it sounds like it had the same problem that Parks had, that there was a blank in the authorization. I'll be happy to submit it, but I don't want to go too far into it because I haven't read it and I don't want to say something wrong. But I'm sure I can address that. I want to say, too, we're not claiming, and I want to be clear about this, we're not claiming they had to that they've waived the arguments because they didn't test the release. We're not saying that. We're saying that we fully complied with the statute because or at least substantially complied with the statute because they had access to all the medical records, period. If they don't want to use it, nobody can make anybody get the records. We can send them the information, we give them access to the records, which Mr. Moxley did, but nobody can make somebody go get the records and investigate the case. If they don't want to investigate the case, they don't have to. I suspect that this is really driven more by a desire to come up with a defense than it is actually not wanting to investigate the case. The Judge Wooten did consider the affidavit. They said he didn't consider the affidavit. His order specifically says he considered the entire record, based on the entire record in this case, which in Ms. Hernandez's affidavit was in the record. So I don't think that that's true that he didn't consider it.
Question, Ms. Lane raised the issue that case law supports. You can't rely on the notice letter. Earlier we addressed the issue of, well, they all got this letter that noticed everybody that was provided such and such. How does that tie into your argument when there's case law that says you can't compound I think the word she used.
Right, and so what she's talking about is a compound authorization. That's different than what we're talking about here. A compound authorization is where a release of medical records is tied to some other legal document, like we'll release your records if you agree to pay your medical bills, or we'll release your records if you agree to waive any claims against us, or we'll release your records if you'll sign this settlement agreement, those types of things. A compound, that's what a compound authorization is. It's not that you have to look in to see, I mean, in every case, the defendants get a list of providers so that they know who they are. So in the scheme of things, I mean, when they're doing their investigation, that's the point of the investigation, so that they know who all the other people that are getting notice letters so that they can investigate the case. To say that because there was an issue about who the other people were getting notice does not make this a compound release. Those are completely different things legally, and they're conflating the two, again, improperly, in my opinion. I've got 2 seconds left, so I'm going to shut up unless there's any other questions.
I see none. Thank you, Mr. Smith.
Thank you.
Thank you, parties. We will take this matter under advisement and get you a written opinion as soon as possible. Thank you. You may be excused.